may be asking yourself, do nurses, advanced practice providers, and other licensed healthcare professionals need malpractice insurance? Well, let's talk about the limitations of employer coverage. First, let's talk about why you might want to have your own coverage and not rely on your employer's insurance. As a licensed professional working in a facility, that facility typically does have professional liability coverage, which could and should protect you to an extent. Generally, it covers the employee and it'll represent you for depositions and representation if you go to trial. However, it's important to consider that the client for that policy is the hospital or the employer, and not you as the individual healthcare professional. Suppose that the hospital is sued due to an adverse outcome directly related to an error or an omission on your part. This could potentially demonstrate a conflict of interest between you and the hospital. At the stage of deposition, and although rare if it does go to trial, the lawyer is going to do what is in the best interest of his client, meaning your employer, which hopefully is not at your expense. With your individual professional liability policy, your own attorney will also be at the deposition or trial to defend you and represent your best interests. Also, if a settlement or judgment is awarded against the hospital, they could in turn file a claim against you to recoup those costs. An actual example of this is a wrongful death case from New York, in which a large medical practice that employed a nurse practitioner had an allegation of negligence that led to a claim. Neither the physicians in this case nor the nurse practitioner had their own personal medical malpractice policies and used counsel that was assigned to them by their collective group policy. The plaintiff's attorney settled with the nurse practitioner and dropped her from the case, but pursued the case against the physician and the practice. The jury found for the plaintiff, and the award was $2 million. The insurance company, who represented the doctors and the nurse practitioner, then went on to sue the nurse practitioner to help recoup those losses. This is an example of a conflict of interest and why practitioners generally want to have professional liability coverage personally to protect themselves and their assets. Second, let's talk about the different levels of coverage for you under your employer's policy. It's important to know if you would have coverage for situations other than medical malpractice claims, such as defending you in response to an action by your licensing board. Anyone can file a report with the licensing board. It happened to me. And once the board receives a complaint, the wheels are in motion for an investigation. You, as the practitioner, will be notified, and the board may request a written response to the complaint. It's important that you have legal counsel before responding in order to review the facts of the complaint and develop a strategy for responding to the board's investigation. If you have coverage, then through your personal medical malpractice company, you would have access to counsel to assist you with navigating this process. Conflicts of interest and licensing actions, these are two good reasons to carry your own professional liability policy.